Is there such a thing as a human right to a healthy environment? David Boyd thinks there is. A leading environmental lawyer and legal scholar based in British Columbia, Canada, David Boyd has, in a single year, 2012, published 2 books on the subject. The first of these, The Environmental Rights Revolution, is a survey of the worldwide trend to entrench such rights in the legal system, often by including them in the national constitution. It turns out that 142 nations now recognize a legal obligation for the government to protect the environment, and 95 nations accept that their citizens have a legal right to live in a healthy environment. Most common law countries, whose legal systems are based on their British heritage, don't recognize either of these rights, and that includes Canada. So David Boyd's second book in 2012 is The Right to a Healthy Environment, Revitalizing Canada's Constitution, which argues strongly that embedding such rights in the Constitution would have a profound impact on Canada's deplorable environmental performance, as it has had in many other countries.
A constitutional right means that it's the highest or supreme law of the land. It enjoys the highest level of legal protection possible in these legal systems. And it's also something deeper and more profound. It's a reflection of society's most cherished and deeply held values. So it reflects a real emergence of consciousness over the past 4 decades.
It's quite amazing when you put it in that way, that the healthy environment is a core. Human beings can't get along without it, but it's been so overlooked or so invisible.
Well, it's been a core concept in many Indigenous legal systems for millennia. So whether it's the Haida on Canada's west coast or the Mi'kmaq on Canada's east coast, environmental rights and responsibilities are a cornerstone of traditional Indigenous legal systems. But in the Western world, it's a concept that really only came to light 50 years ago when Rachel Carson wrote Silent Spring and talked about everyone's right to live in an environment free from chemical poisons.
Is there anything else, or is there anything that those countries have in common, those countries that have entrenched environmental rights?
Not really, no. They're found all around the world, in the north, in the south, in wealthy countries, in poor countries, in Christian countries, in Muslim countries. So it's something that's really not limited to a geographic or political type of culture. It's something that's permeated the entire globe.
But you can describe some common features among those countries that do not have entrenched constitutional rights, right?
Yeah, it's very interesting. The countries that are lagging behind are predominantly former British colonies, so including the United Kingdom itself, which doesn't have a written constitution. And then, so former British colonies who have a similar common law legal system. And then also about 25 small island states around the world. And the irony there is that small island states are really at the forefront of the global movement to recognize the right to a healthy environment, and yet they don't recognize that right in their own constitution. So that's something that I'm beginning to work with people from the Alliance of Small Island States to move them forward both legally and morally in their efforts.
Why would they not have that?
Simply because they have constitutions that were brought in decades ago, and they have often more important, what they perceive to be more important economic, social, and political crises that they're grappling with on a day-to-day basis. And for many of those small developing countries, the notion of constitutional reform seems like something of an abstraction compared to the day-to-day challenges that they face.
But your research, when you actually go and look not just at what's in the Constitution, but at what happens in those countries, in countries that do have this protection, suggests that it really is not an abstraction at all. Eh?
No, very much so. In fact, the research I've done on 95 countries around the world whose constitutions explicitly mention the right to a healthy environment is that it has a transformative effect on their environmental laws and policies. It has a pervasive effect on the court systems in those countries so that people can go to court and actually enforce their right to a healthy environment when it's being violated. And most importantly of all, there's a clear correlation between environmental provisions in a national constitution and superior environmental performance, which at the end of the day, that's what we're trying to achieve, is cleaner air, universal access to safe drinking water, non-toxic environment, and healthier ecosystems.
Tell me a bit about the way that this actually plays out in practice, and tell me about Beatriz Mendoza, for example.
Yeah, well, certainly one of the most compelling examples of how the constitutional right to a healthy environment can make a tangible difference in people's lives comes from Argentina. Argentina amended its constitution in 1993 to include the right to a healthy environment, and there's a woman who's become a national heroine in Argentina by the name of Beatriz Mendoza, who moved to a very poor and polluted neighborhood of Buenos Aires, the Argentine capital, about a decade ago. And within a couple of years of moving there, Beatriz Mendoza began to experience some serious health problems. So she actually went to visit her doctor and found through a series of tests that her blood contained extremely elevated levels of a chemical called toluene, which is a byproduct of petroleum refining. And of course, the area in which she was living is home to a number of petroleum refineries, other petrochemical facilities, and a lot of heavy industry. And so toluene is a chemical that affects the central nervous system and is a highly toxic substance. And Beatriz Mendoza, to her credit, didn't take this sitting down. She gathered a group of neighbors together, they hired a lawyer, and they filed a lawsuit against the federal government, the provincial government, and the municipal government, as well as 44 large corporations, arguing that the pollution in the Riachuelo watershed violated their constitutional right to live in a healthy environment. That lawsuit wound its way through the Argentine court system, and in 2008, the Supreme Court of Argentina, the highest court in the country, issued an incredibly powerful and poetic judgment in which it imposed a whole list of obligations on the government to carry out specific activities on a very fixed and urgent timeline. So for example, it ordered the government to create drinking water treatment plants, to build sewage treatment plants, to clean up the river and restore the river banks, to provide social housing for people who are living in riverside shanties, and to create a management plan for the entire watershed that would result in regular inspections of every business that was creating air or water pollution. So that was in 2008. 4 years later, the extent of progress in implementing that court order is nothing short of extraordinary. The government of Argentina, in collaboration with the provincial and municipal governments, set up a new watershed management agency to oversee implementation of the court's order. And they are spending over $1 billion a year in terms of building the infrastructure that the court ordered them to construct. So for example, they've built 3 new water treatment plants, which are serving millions of citizens. They've built or upgraded 11 sewage treatment plants, again serving millions of citizens. They've created 139 monitoring stations to measure air quality, water quality, soil contamination. They've closed down and cleaned up 169 illegal landfills in that watershed. They've hired 250 environmental inspectors to look at all the businesses and make sure that they're in compliance with the law. And just to put that number, 250 environmental enforcement officials, in context, that's more than Environment Canada has for the entire country of Canada. They've also closed down completely 484 different businesses who were polluting the Riachuelo River. And they've planted thousands of trees along the banks of the river, created public parks, and one of the most touching parts of it is that the families who were formerly living in literally tin and cardboard shacks along the banks of the river have been, thousands of families have been relocated into newly constructed social housing where children are living with running water and electricity for the first time in their lives. So it's just a truly remarkable story of progress in a very short period of time, all of which can be traced back to the constitutional recognition of Beatriz Mendoza's right to live in a healthy environment.
Wow, one person. And
one person working with a team of neighbors and a group of lawyers and assisted by non-government organizations. Have to give credit to the court, the judges who sit on the Supreme Court of Argentina. The court also did a couple of really interesting things to make sure that government followed up on the court order. They have the federal minister of environment in Argentina and the head of this new watershed management agency come and sit before the court every 3 months and provide a report to the court on their progress. And the judges ask them very challenging, difficult questions about the progress or lack thereof. And they also set up a system where politicians are fined on a daily basis if the court's timelines aren't met. Back in 2010, there were some timelines that weren't met, and the court followed through on its promise to fine politicians, and I can tell you that certainly jump-started the process.
now that's an extraordinary role for a court to take, right? You would think that, like coming out of the Canadian context, I would sit as the Supreme Court and say, let this be done, and then I would depend on another agency to actually enforce it. But you're telling me that the Supreme Court itself is having these people come back and talk directly to it. And
yes,
say, yes, sir, we did what you said.
And that is somewhat extraordinary, but around the world, the role of courts is to make sure that governments obey the Constitution. So once a right to a healthy environment gains that constitutional status, then it provides an unprecedented level of accountability. Governments can't just make promises and violate them. So in Argentina, for example, governments for decades had pledged to clean up and restore the Riachuelo River. It's been known for years as one of the most polluted watersheds in South America. But it wasn't until there was that constitutional commitment that a court could hold the government accountable and citizens could use the courts to demand that accountability. And you can contrast that situation with Canada, where we have extensive contamination of the Great Lakes, which are the water body that's really at the heart of our nation, both culturally and ecologically. And there have been government promises in Canada to clean up the Great Lakes, as you know, dating back to the 1960s, and yet progress is painfully slow. Many people still suffer devastating health consequences because of the pollution in the Great Lakes. And there is just no way that Canadians at this point in history are able to hold governments accountable for those broken promises.
You said the other night that you reckon that in Canada that this costs us 30,000 deaths annually, that was the environmental issues that could be solved if we had the right to sue over them.
Yes, well, the World Health Organization has conducted studies in every country on Earth estimating the proportion of deaths and illnesses that are caused by environmental pollution and other environmental hazards. And for Canada, the World Health Organization's estimate is approximately 30,000 premature deaths a year. And that's a very daunting figure, but as the World Health Organization points out, those are preventable problems, because if we address the environmental pollution that's at the root of it, then we can actually prevent those illnesses and those premature deaths.
I think that sort of an urban Canadian hearing this is going to roll his eyes and say that can't possibly be true. What kind of deaths are they? I mean, who's dying and what are they dying of?
The single largest group within that is deaths caused by air pollution. And what people don't realize is that there are air contaminants that you can't see or smell that actually enter into your body when you breathe them in and cause not respiratory illness, which many people think, well, if there's dirty air, it must affect my breathing system. But they actually get into your bloodstream, and those tiny particles contribute to cardiovascular disease. And as you know, heart disease is one of the leading killers in Canada. But there's also deaths from respiratory ailments as well that are attributable to air pollution. There are cases of cancer that are clearly linked to environmental hazards such as asbestos, secondhand smoke. And so the numbers that the World Health Organization has published are consistent with studies done, for example, by the Canadian Medical Association.
See, I thought you were going to tell me that this was, to some extent, out of sight, out of mind. Like, for example, Aboriginal deaths, which is would be another issue. But what you're saying is this knows no class structure. These are.
No, absolutely, and I can tell you, I spoke with a cardiologist in Montreal, Dr. Francois Reeves, who said very clearly to me that he can tell when he's going to have a busy day as a heart surgeon when there's an air quality advisory out. And it's that clear, the correlation between poor air days and more people coming to hospital and passing away because of cardiovascular disease.
That's stunning.
Mm-hmm.
That is stunning.
Yeah.
Let's go to some other countries, because you also have given some examples from around the world of different countries. I mean, the Mendoza case is probably the most spectacular and compact, but there are a number of others, right? Yes,
well, I could tell you stories from 95 different countries. I mean, you've got France, which has one of the world's oldest constitutions, but was silent on the environment until the year 2005, brought in a really powerful charter for the environment, added it to their constitution, and scholars in France say that the Charter for the Environment has had impacts wildly beyond expectations. So, for example, France last year became the first country in the world to pass a law banning the practice of fracking or hydraulic fracturing for oil and gas, a problem which many people here in Canada and the United States are deeply concerned about. In Finland, hydroelectric projects have been canceled because of concerns that the impact on migratory bird habitat would violate the constitutional right to a healthy environment in Finland. In Brazil last year, there was an oil spill off the coast by Chevron, and the Brazilian enforcement officials immediately fined Chevron $28 million, which is a sum greater than the total amount of fines levied under the Canadian Environmental Protection Act since it was passed in 1988. And then on top of that, the Brazilian officials are pursuing a civil lawsuit against Chevron in which they're seeking billions of dollars for damage to the environment. And they've also filed a criminal prosecution against Chevron executives seeking prison sentences of up to 30 years in jail. So that's a couple examples from around the world. I could really go on and on, whether it's protecting endangered sea turtles in Costa Rica, endangered salamanders in the Netherlands, cases requiring the cleanup of polluting facilities in India, cases in Thailand, striking down approvals for new petrochemical and oil refineries, really cases from every corner of the world, and stronger laws and policies in all of these countries as well that have a systemic transformative effect.
Well, three things sort of bump out of that. Now, the right would say, what you're giving me is negative examples that interfere with economic growth, right? That you're basically, who's going to go back and explore for oil off the Brazilian coast given what's going on there? Or who's going to build hydroelectric power in Finland if you can't do it because there's some watershed that can be disturbed.
That's the natural response of big business, but the reality is if you look at countries like Norway and Sweden and Finland that have these strong provisions in their constitutions, they also are world economic leaders. I mean, they come at the top of the international rankings for environmental performance and also for things like innovation and competitiveness. And so what the Scandinavian countries have done is shown that there's a myth about this trade-off between environmental protection and economic competitiveness, and that what really happens is that when you pass stronger environmental laws and policies, that stimulates innovation, it stimulates creativity, it stimulates ingenuity, and it creates a virtuous circle where those countries are then attracting more investment, attracting a higher caliber of human people to their countries, and their healthcare costs go down. Sweden, which has had the strongest environmental laws in the world for decades, has the slowest rate of increase of healthcare costs of any industrialized nation, which the Swedes themselves attribute to their strong environmental policies. So there's a virtuous circle that happens here, and it's a really good news story that countries like Canada and the United States really need to understand and appreciate those lessons that can be learned elsewhere. And then you have countries like Brazil, which is one of the most rapidly developing countries in the world, and they have much stronger environmental laws, including laws governing offshore oil and gas exploration, than a country like Canada. So the lesson is that it's not that constitutional recognition of the right to a healthy environment will stop economic activity. It'll require that economic activity be done properly in a way that benefits people both today and into the future.
It's fabulous.
Mm-hmm. There's a better way of doing business is the bottom line.
Yeah. Now, what prompts the Scandinavian countries? Because you've also mentioned the incredible influence of the Stockholm Declaration 40 years ago. Let's go back to that. Tell me about the Stockholm Declaration.
Well, the Stockholm Declaration was a political statement that arose out of the very first Earth Summit, which was held in Sweden back in 1972. Canada actually played a major role in organizing and leading that conference. And the Stockholm Declaration was the first formal statement that people have a right to live in a healthy environment and a corresponding responsibility to protect the environment. And since that 1972 declaration, which wasn't a legally binding treaty or didn't have any enforceable provisions, but it's had a transformative impact on both environmental law and constitutional law around the world. So it was just 4 years after that Stockholm Declaration that Portugal became the first country in the world to recognize the right to a healthy environment in its constitution, followed by Spain in 1978. And many of the countries who have incorporated the right to a healthy environment in their constitutions point to the Stockholm Declaration as the source or one of the inspirations for doing so. So it really was a watershed moment in bringing together for the first time really the concept of environmental protection on the one hand and human rights on the other.
You mentioned responsibility there too, and I think you've also mentioned that some of the Aboriginal or indigenous traditions couple that very closely, that you have a right to a healthy environment, but you also have a responsibility to provide one. Right. That seems also a very un-Anglo uncommon law perception.
Yes, that's right. And so if you look at Canada's Charter of Rights and Freedoms, it's all about rights and freedoms, and there's nothing in there at all about responsibilities. We act as though the only responsibility is a kind of unwritten responsibility upon government to respect, protect, and fulfill our rights. But the reality is, given the global ecological crisis that we find ourselves in the year 2012, we all, both individuals, governments, businesses, civil society, we all have a responsibility to do things in a different way in order to protect the environment upon which our very health and well-being and the future of humanity depends.
Now, should that be part of a constitutional law on the subject of the right to a healthy environment? I mean, should that be a piece of the law that on the one hand it gives you the right, but on the other hand it imposes on you a duty?
Absolutely.
Yeah.
And so
is that typical? Does that happen?
Well, there are actually almost 150 constitutions in the world that clearly state that the government has a responsibility to protect the environment, and there are 84 that also impose a corresponding responsibility on individuals. So it's becoming increasingly prevalent, and I think that's a very positive step to make it clear that it's not just a right, but that we also have a corresponding responsibility.
In a way, it's a call to act as adults, isn't it?
It is, and I think that the fact that this has gained such global prominence in such a short period of time reflects a growing maturity of human consciousness, if you will, that we've finally come to terms with the fact that this is a threat to our very our health, our well-being, and our existence, and it's something that we have to take give us level of credence to on par with the other fundamental human rights, such as the right to life and the right to freedom of expression and freedom of religion.
And this also has the interesting effect of raising the possibility that lawyers can be heroes. Not the way we usually think.
Yes, well, I was giving a talk in Wolfville last night and I made a Freudian slip and I said liars instead of lawyers, so you have to be careful. But yes, there's a role for lawyers to have a positive influence on society, certainly. But so I think of the right to a healthy environment and the responsibility to protect the environment as having the transformative capacity to bring us from an era of human destruction and environmental degradation into an era where we recognize our fundamental connection and dependence upon ecological systems. And so the need that we have is to transform our legal systems, because legal systems have such a pervasive influence on human behavior. But the reality is we're so far from being sustainable at this point in history that we also need systemic transformations of our economic systems. We need systemic transformations of our education systems so that ecological literacy becomes on par with reading, writing, and arithmetic. We need transformations of our healthcare system so that we actually prevent illnesses rather than simply treat people when they're sick. And we also need a systemic transformation of our democratic system so that everyone's vote and everyone's voice actually counts.
You know, what you've just said there basically contains the outlines of a world and a society that's infinitely more desirable than the one in which we find ourselves, and yet we have such a hard time kind of getting people to take seriously, I guess, the whole philosophy of about our relationship with the environment.
It's true, but another very interesting field of study that's just emerged in recent years is the study of human happiness. And it's remarkable to learn that, for example, people's happiness increases with a certain degree of economic wealth and then plateaus. It doesn't matter. Once you have the basic necessities of life, having more economic wealth doesn't increase your happiness. It's things like friendship and community and the social bonds that we develop. And countries like Sweden, Norway, and Finland in Scandinavia, and increasingly countries throughout Latin America, have really grasped onto this concept and are shifting their cultures, I think, in ways that are profoundly hopeful and inspiring to the rest of the world in terms of moving forward. Ecuador has a new constitution that's based on an indigenous concept called sumac cauce, which translates roughly as the good life. And so Ecuador's vision, its roadmap for where it wants to go as a society, is the pursuit of the good life for all of its citizens. And I think that's just such a beautiful way to frame a society's highest level of aspiration, something that we could all learn from.
And they were one of the first to pass legislation on the rights of Mother Earth.
Yes, and in fact, as a lawyer, I have to just correct you there. They were the first to, along with Bolivia, to pass constitutional recognition of the rights of nature and Mother Earth. So in Ecuador and Bolivia, the planet, ecosystems, mountains, rivers, and species all have legally enforceable constitutional rights. And in fact, the first court case last year in Ecuador was when a highway construction project damaged the Rio Vilcabamba, or the Vilcabamba River. And some Ecuadorian citizens went to court, and an Ecuadorian court issued an extraordinary judgment that said the constitutional rights of the Rio Vilcabamba have been violated, and according to the Constitution, the river has a right of restoration, and so the government has had to carry out a restoration project on the Rio Vilcabamba. Similarly, Bolivia has a new law called the Law on the Rights of Mother Earth, which sets forth in great detail all of the various rights of nature, also clarifies that the citizens, governments, businesses, everyone in Bolivian society has a responsibility to protect Mother Earth, and the law also establishes an ombudsperson to take steps to defend Mother Earth's interests. And Bolivia has actually led the charge at a global level. There's been discussions at the United Nations General Assembly this past year about creating a universal declaration of the rights of Mother Earth, which is something that I think is a very powerful concept in terms of highlighting the importance of changing our ways in fundamental fashion.
I want to come back to that, but before I do, I want to go back to Ecuador, because one of the questions I think that occurs to people from our tradition is, okay, you give the right to the river to, not to be undisturbed, I guess, but to, to have its well-being respected. And how do you enforce that? And I guess what am I right in understanding that in Bolivia, a citizen perceiving that would have an obligation to take some kind of action, and that's how it would get into the legal system?
Yes, I mean, a citizen would have a moral obligation, but also a legal right. So in Bolivia and Ecuador, and in fact in many countries where the constitutional right to a healthy environment is recognized, citizens are able to bring cases before the courts in situations where their personal health isn't being directly harmed, their property's not being harmed, but for example, the habitat of sea turtles is being threatened, or the well-being of sharks in the ocean is being threatened by the practice of shark finning. So individuals are able to bring lawsuits that force governments to take actions to protect a healthy environment. And this goes back to our earlier conversation about, well, does that mean healthy for humans or healthy for nature? And as I said, those things are really inseparable. I mean, we have to have a healthy environment in order to have healthy humans. And so there are cases around the world where courts have upheld the constitutional right of an individual to a healthy environment in ways that have created additional protection for the natural world.
It kind of evokes the best in human beings, doesn't it? I mean, it rewards us for being responsible and thoughtful and considerate and,
yes,
and thinking long term rather than short term.
Oh, very much so, and I think that's why the concept appeals to people of every stripe around the world. And polls in Canada show that over 90% of Canadians believe that government should recognize their right to a healthy environment. So certainly there's widespread public support for this concept.
Well, the first time I ran across this whole idea was an essay by Christopher Stone called "Should Trees Have Standing?" Towards Natural or Legal Rights for Natural Objects. Mm-hmm. One of the things he imagined was groups of citizens applying for stewardship with respect to certain natural features, like we are going to be the group that cares for this mountain, or we're going to be the group that cares for this valley, and so on. Does that emerge is that a feature of life in countries where this right is recognized?
Yeah, absolutely. And in all of these countries, there are literally thousands of citizen groups that focus on everything from a local creek or a particular species to national parks and large ecosystems. And so, people are protecting their local environment, and they have a whole variety of motivations for doing so. Some people are doing it out of self-interest to protect the source of their drinking water. Others are doing it because they think they should protect the environment for their children. But the end result is the same, that empowering those people by recognizing their constitutional right to a healthy environment gives them the tools they need to get the job done.
Okay, now let's go to the UN, because the prospect, it seems to me, of a universal declaration of this kind, boy, that would be a very powerful impetus for other countries to follow suit.
It would be, yeah. There's no question that in much the way that the Stockholm Declaration spurred close to 100 countries to amend their constitution to recognize the human right to a healthy environment. Universal Declaration of the Rights of Mother Earth could take us that next step in the evolution of our conception of rights. I mean, you have to think about human rights as a subject that's not fixed in time. I mean, we all know that if you cast your mind back 100 years or so, we didn't consider Aboriginal persons to be people who were worthy of human rights. African Americans didn't have human rights. Even in the 20th century, women didn't have the full range of human rights. And so there are philosophers such as Roderick Nash and Christopher Stone who make the compelling argument that in the evolution of human consciousness, it's natural to take the next step and extend rights to nature. And in funny ways, our legal system already extends rights to things such as corporations. So there's precedent for extending rights beyond just human species.
Well, I think Stone calls those jural persons. These are persons which are not persons, and like corporations, but also like universities and churches and ships.
Yes,
you know,
absolutely
all these
right.
have legal
these
rights.
Are all legal persons.
Yeah. And so, I mean, he also makes the interesting point that is well, reflecting what you said, that that the history shows us the constant extension of rights to things that were not thought to be susceptible to possessing rights, and that this just seems to be, as we evolve, one of the growths that carries on.
Mm-hmm. And it's a funny characteristic of humans that we often think that we're coming up with new ideas when really ideas have been around for centuries. So in the course of my research on this subject, I came across a book that was written by a Muslim Sufi 1,000 years ago called The Animals' Lawsuit Against Humanity, where a group of animals banded together and brought a lawsuit against human beings for their mistreatment, for the violation of their rights. And so that's a story that not only is a part of indigenous law dating back centuries, but is a part of Muslim Sufi law that dates back an entire millennium.
That's a phenomenal fact.
Mm-hmm.
I've actually I want to read the book. It just sounds to me like it should really be essential reading on a number of grounds. I mean,
yeah, it's a great story.
Yeah. There's also a suggestion somewhere buried in here that the Canadian legal system is founded in part on Indigenous concepts, and that perhaps there is, you could tease out of even the existing structure a right to a healthy environment, mm-hmm. even in Canada. And there's people in Sarnia that I think are pursuing that.
That's right.
Yeah?
So Canada has 3 founding legal systems. We have the British common law, the French civil law, and we also have the neglected category of Indigenous law. And as we've discussed, Indigenous law throughout First Nations in Canada includes environmental rights and responsibilities. So there's a First Nation called the Aamjiwnaang First Nation, whose reserve is on the outskirts of Sarnia, in the most polluted place in Canada, a place that's home to over 60 major industrial facilities such as oil refineries and petrochemical plants. And the Aamjiwnaang First Nation, the people there are suffering a devastating set of health problems because of those industrial facilities. They have elevated rates of childhood asthma, elevated rates of cancer, including leukemia, birth defects. And so 2 very courageous individuals from that community, Ada Lockridge and Ron Plain, have actually filed a lawsuit against the Ontario government and Suncor, one of Canada's largest oil companies, because of the approval of additional pollution on top of what they're already dealing with. And their legal argument is that Section 7 of the Canadian Charter of Rights and Freedoms, which is the right to life, liberty, and security of the person, includes an implicit right to a healthy environment. And from an ecological perspective, that makes complete sense. How can we have a right to life without a right to a healthy environment, given that we're dependent on ecosystems for the air we breathe, the water we drink, and the food we eat? And so they've brought this lawsuit. They're currently before the courts in Ontario. And it's a David and Goliath battle, there's no question. They're facing defendants with deep pockets and far more resources than they have. But what's encouraging is that courts in 20 other countries around the world, from Argentina to Italy, have already reached the conclusion that the right to life includes the right to a healthy environment. So there are precedents that the Aamjiwnaang people can rely on from around the world, as well as from their Indigenous legal system, that make the case that both their right to life and their right to a healthy environment is being systematically violated by industrial pollution.
Now, you would think that the Ontario government would be on their side.
You would hope that the Ontario government would be on their side, but in fact, and this is a very disturbing statement, but we've talked mostly about constitutional recognition of the right to a healthy environment. There are some countries who don't recognize it in their constitutions, but their environmental laws do. There are other countries who don't recognize it in their environmental laws or their constitution, but have signed international treaties that include it. And if you add up all of the countries in the world that have recognized the right to a healthy environment, you get 177 out of the 193 members of the United Nations, which is truly extraordinary. It means there are only 16 countries left in the world that have not yet recognized this fundamental human right. Canada, the United States, Australia, New Zealand, China, Japan, Laos, Cambodia, North Korea, Brunei, Darussalam, Lebanon, Oman, and Kuwait.
The United Kingdom?
The United Kingdom has actually signed an international agreement called the Aarhus Convention, which includes recognition of the right to a healthy environment. But what's really striking about that is that, so you have this, over 90% of the countries of the world that recognize this right, a small number, 16, that don't. And Canada and the United States are the only countries in the world that actively oppose recognition of this fundamental human right. So Canada participated in the negotiations of this Aarhus Convention, which is an international agreement on the right to information about the environment, to participate in environmental decisions, and to have access to justice when your right to a healthy environment is being violated. And Canada opposed that, the inclusion of the right to a healthy environment in that treaty. And at the end of the day, everyone else said, Canada, bugger off. We're going to include the right to a healthy environment. And Canada, as a result, has neither signed nor ratified that treaty. 45 other countries in Europe and Asia went ahead and did so. The United States is facing a case brought by citizens of Mossman, Louisiana, in the heart of the American oil industry. And those predominantly poor and black citizens of Mossman, Louisiana, fought their battle through the American court system, weren't successful, have brought their case now to the Inter-American Commission on Human Rights, and the US government, under President Barack Obama, has argued that those people have no right to a healthy environment because there's no such thing. And it's a truly extraordinary development for Canada and the United States to be the global renegades in terms of recognition of this most basic and fundamental human right.
You know, that's an astonishing fact, and particularly given the way that Canadians think of themselves as being quite progressive people and quite sensitive to a lot of these kinds of things. And in fact, this is illusory in the environmental sphere, because it isn't just that we don't recognize the right, it's that our environmental performance is much worse than most Canadians, I think, would expect.
Yes, Canadians are surprised by how bad Canada ranks when you have international comparisons of environmental performance. For example, amongst the wealthiest OECD countries, Canada ranks 24th out of 25. When the highly respected Conference Board of Canada performs its comparisons, Canada ranks 15th out of 17. And so there's a real disconnect between how Canadians view themselves and view their country and our actual performance on these matters. And in terms of the right to a healthy environment, you get a similar disconnect, because over 90% of Canadians think that government should recognize their right to a healthy environment. Over 50% of Canadians think it's already in the Charter. So, you know, there's these widespread misperceptions. And I think that the challenge for those of us who wish to move forward on this issue is to somehow break down those Canadian myths, because if government really isn't reflecting and respecting the values that we cherish as Canadians, well, then we should throw the bastards out and get somebody in office who's going to do what the people want them to do.
Yeah, right. It's almost as though you have, well, I guess maybe what it tells us is that governments at both provincial and federal levels are largely captives of people who benefit from there not being such a right. Is that?
No, that's right, and I think that is a sign of a very unhealthy democracy. I mean, we live in a country, Canada, where about 26% of the voting population elected a majority government. Well, how does that work? We have a government in office which the majority of Canadians not only don't like, but have very strong emotions against. And so we need to reform our electoral.
And didn't vote for it.
And didn't vote for it. So we need electoral reform quite desperately in this country to basically reinvigorate and bring our democracy back into a healthy state.
Okay, so now how would we do this? Because here we have a country with an unwritten, well, largely unwritten constitution, not entirely unwritten constitution, but how do you go about doing a constitutional or other recognition of the right to a healthy environment?
Well, in Canada, there's three pathways to recognition of the right to a healthy environment. One is through direct amendment of the Constitution, which requires Parliament's approval and the approval of 7 of the 10 provincial governments. And all of those approvals have to be secured in a 3-year time frame. So it's a politically daunting thing to achieve. But as Nelson Mandela said, things always seem impossible until they're done. And in fact, the Canadian Constitution, which was repatriated in 1982, since that time has been amended 11 times. So the challenge is daunting but not impossible. And that's the direct amendment of the Constitution is probably the most compelling because it has not only the powerful legal impacts, but it has a transformative cultural potential as well. So the Charter, of course, in 1982 has had a profound impact on issues such as the recognition of same-sex marriage in Canada and our values and cultural attitudes towards equality. The second route towards recognition of the constitutional right to a healthy environment in Canada is through the courts, is through lawsuits such as the Aamjiwnaang First Nation has going in Canada, arguing that there's an implicit right to a healthy environment in existing constitutional provisions, such as Section 7 of the Charter. And then the third route is also a legal route, but it's slightly more obscure, and that is through a process called the judicial reference. And many Canadians will remember the Persons case back in the 1920s. A judicial reference basically allows governments to ask the courts hypothetical legal questions. So, for example, there have been over 100 judicial references in the course of Canadian history on issues such as same-sex marriage, whether Quebec can legally secede from the country, who owns offshore natural resources. And back in the 1920s, a group of very powerful women led by Nellie McClung, Emily Parlby, and others started campaigning to have women recognized as eligible for appointment to the Canadian Senate. It's kind of shocking today to think that women weren't eligible for the Senate, but anyways, back in the 1920s, the prevailing legal opinion was that women weren't persons as was required to be appointed to the Senate under the British North America Act. So they prevailed upon the federal government to initiate a judicial reference. The federal government asked the Supreme Court of Canada, are women persons for purposes of Section 24 of the British North America Act, and therefore eligible to be appointed to the Senate? And the Supreme Court of Canada, in what must be its most infamous decision, said no, women are not persons for purposes of being appointed to the Senate. Now, fortunately at that time, there was an appeal process to the United Kingdom, to the Judicial Committee of the Privy Council, and common sense prevailed, and the Judicial Committee said, for God's sake, of course, women are persons, and that decision in 1930 really marked a turning point in the evolution of women's rights in Canada. So I think there's potential for a similar kind of judicial reference to be brought here in the 21st century that would advance the cause of the right to a healthy environment in Canada.
Now, who can bring such a reference? I mean, obviously the feds can, they did with the Clarity Act.
Well, and interestingly enough, the federal government, any provincial government, or a territorial government can bring a judicial reference. So I'm particularly interested in the situation in Nunavut, where the Inuit are at the front lines of bearing the impacts of global climate change. The Inuit have not been successful in trying to persuade Canada as a country to take strong action both at home and internationally on climate change. But the government of the Nunavut territory could bring a judicial reference seeking to have the right to a healthy environment recognized in the Canadian Constitution, which could have a transformative effect on the legal system in Canada and eventually on our culture and our environmental performance. So that's something I'm hoping to talk to politicians in Nunavut about in the coming months.
Well, that sounds like the most lively possibility for moving this forward, right?
Well, in the short term, but in the long term, I think that we will have a new generation of political leaders for whom the environment is a core value. We have a federal New Democrat leader now, Thomas Mulcair, who, when he was the environment minister in Quebec, oversaw the inclusion of the right to a healthy environment in Quebec's provincial Charter of Human Rights and Freedoms. So the federal NDP has endorsed this concept. The federal Green Party has endorsed this concept. The Liberal Party certainly is the heir of Pierre Elliott Trudeau, who had such a profound influence in bringing the Charter of Rights to Canada. And so I think there is actually potential in the near, not in the immediate term given our current federal government, but in the near-term future, I think that given the right political leadership and given the widespread public support for this issue, this is something that could come to pass.
Does the Quebec situation, does their inclusion of the right in their legal system, does that give leverage to the rest of the country? I mean, couldn't I go to court and say, look, we cannot have a legal system here which gives a fundamental right to the citizens of Quebec and doesn't give a fundamental right to me as a citizen of Nova Scotia?
You could try that, Don, but you wouldn't get very far in the Canadian legal system.
No.
It can be used as a leverage in political context to say to the government of Nova Scotia, why does Quebec recognize this right and not the government of Nova Scotia? But it doesn't carry any currency outside of Quebec.
You would think the rights of a Canadian citizen should be across the country, right? Not just, they shouldn't be further ahead in one province than the other.
I agree 100% with you from a moral and political perspective, but the solution to that is not going to court in a different province. It's getting Canadians united behind the concept of a right to a healthy environment and making our political leaders do our bidding.
Let me take you to the States, because we have three routes that we could possibly get that right entrenched in Canada. What about the States? Because they have a very complex amendment process for their constitution, right?
They do have a very complex amendment process. And in fact, back in the early 1970s, there were efforts to amend the US Constitution to include the right to a healthy environment. The same senator who came up with the idea of Earth Day, Senator Gaylord Nelson, introduced an amendment in Congress, which unfortunately didn't pass. And there were also lawsuits in the 1970s arguing that there was an implicit right to a healthy environment in the US Constitution, none of which were successful. So in the United States, it will be a long and difficult struggle because of the challenges that are inherent in amending the US Constitution. There have been thousands, literally thousands of attempts to amend the US Constitution, and only a couple of dozen of those amendments have ever been successful.
Now, are there other routes there as there are in Canada, like the judicial reference, for example?
They don't have anything similar to the judicial reference, but over time, as the legal system in the United States evolves, it's possible that lawsuits could be brought, again, arguing an implicit right in the right to life.
But thus far that's been tried and it hasn't been successful.
Yeah, it was tried 40 years ago and hasn't really been tried since.
Mm-hmm, mm-hmm. Municipal, we just touched on municipal government, but that's been something you've been very, very interested in, and it's a place where you obviously see some real opportunities. Tell me about that.
Mm-hmm. Well, you know, at the municipal level is where a lot of citizens have their closest interaction with. That's where they breathe their air, that's where they get their drinking water, that's where their trash gets taken away, their recycling gets taken away, that's where they do their composting. So it's really where people are, it's really the nexus for urban residents, which make up 80% of the population of countries like Canada and the US. It's the interface between human beings and the environment. And municipal governments, in the absence of leadership from other levels of government in Canada, have stepped into the breach. You think of Vancouver, which is the greenest city in Canada and working towards being one of the greenest cities in the world. And cities like Vancouver and Montreal has passed a Charter of Rights and Responsibilities at the municipal level, which includes environmental rights and responsibilities. And I think in a country like Canada, where there are political challenges to amending the Constitution, provinces are at different places, have different political parties running them at a point in time, I think we should be making efforts at every different political level to recognize the right to a healthy environment, and by doing so, building momentum piece by piece across the country towards the ultimate goal of changing our Constitution.
Mm-hmm. Now, when Montreal has that right within its municipal government, what does that actually mean in practice? How does that change my life if I live in Montreal?
To be honest, it doesn't have a very direct practical impact, but it represents a recognition that the citizens endorse that right. It represents an aspiration. And the Montreal Charter actually does have one very interesting, innovative wrinkle. It allows any citizen to commence what's called an initiative. So a citizen can draft up an idea for changing an environmental policy in the city of Montreal, or for protecting a new part of Montreal, creating a new park. And they now have the right to formally bring that before the municipal government and have the government study it and create a public hearing process to evaluate it. So that's a real, I would say that's a real step forward in terms of direct democracy, giving people the right to actually put ideas on the table. And the result should be, given the creativity and ingenuity in our society, that we unleash that and harness it in ways that are currently not being done.
Would it give citizens the right to bring a suit against the municipal government for not performing, if it's...
Well, they can actually do that under the Quebec Charter of Human Rights and Freedoms. And so cases have been brought since 2006, and Quebec is certainly ahead of any other jurisdiction in Canada in terms of implementing that human right.
Let's take it out of Quebec. I mean, supposing that were a similar right were passed at the municipal level in Regina or something, would that, in principle, give the citizen of Regina the right to sue the city to improve its performance environmentally?
Well, I have to resort to a kind of slippery legal answer there and say it would depend on the way that the right was recognized. If it was in a legally enforceable bylaw, then potentially it could do that.
Yeah, I'm just curious to know what the possibilities are. I mean, I recognize that you can't say what a hypothetical law in a place we don't even live in might mean to somebody.
So hypothetically, possibly maybe yes.
Yeah, yeah. I want to back off finally too, and I think we're just about running out of time, but I want to back off finally to a sort of a broader issue or a broader matter that you bring up, which is, I think probably for most of us, we tend to think of rights as being inherent, inalienable, just natural consequences of human society or something like that.
Right.
But I think you make a very clear point that there is a whole evolution that's both in time and in consciousness. Rights keep on evolving, and you mentioned this particular right has gained strength because of the convergence of three sort of trends in the world we now live in. Tell me about how rights happen, because and tell me about what rights you see maybe beyond the ones we've been talking about.
Well, rights, the classic statement is that rights emerge and evolve in response to wrongs. So the Universal Declaration of Human Rights really emerged out of the ashes of World War II, when humans saw an unprecedented degree of rights violations. And the right to a healthy environment emerged in the 1960s and 70s in response to an upsurge of global recognition of the damage that human beings were inflicting on the environment and of course on themselves. So the nature of rights, and as you said, the definition of a human right is something that's universal, meaning it's held by all human beings. It's got to be essential to human dignity, and it's also got this character which you alluded to, which means it's regardless of whether governments actually pass laws recognizing these rights, that we have these basic rights, that they're inalienable. So you and I and everyone watching this program has a moral human right to live in a healthy environment. But the catch is that in order for that human right to be enforceable, to make it really meaningful, it has to be enshrined in law. And once that happens, it's that legal alchemy that transforms moral rights into rights that are powerful in our contemporary legal systems and societies. In terms of where we're headed, I think that the right to a healthy environment has spread globally over the last 40 years, more rapidly, according to constitutional law scholars, than any other right in time. It's just been a remarkably rapid diffusion of this idea in a short period of time. And it still has a ways to go. As I said, there's no global treaty recognizing the human right to a healthy environment. There are regional human rights treaties ratified by 118 countries, but at the end of the day, every country in the world, every citizen in every country should have their right to a healthy environment recognized. And I think we're seeing in the emergence of the debate about the rights of nature, we're seeing a very clear indication of where this should and probably will evolve in the decades ahead, that what starts out as a human right to a healthy environment will over time broaden out into widespread recognition of the rights of nature in ways that are morally compelling and also societally beneficial, because recognizing the rights of nature is not only the right thing to do from my perspective morally, but will have salutary consequences for human well-being over the course of the long term. You have to remember, human beings are not built for sprinting. We're built for endurance running, and to achieve a sustainable society, is like running an ultramarathon, and yet we have kind of mistaken ourselves or deluded ourselves into thinking we have to run as fast as we possibly can. We have to consume more resources. We have to become increasingly wealthier, when in fact our whole physical evolution and our cultural evolution goes in terms of being ultramarathoners and not sprinters.
Mm-hmm. Which is an encouraging thought, that we get there over the long term.
Yeah, I mean, you look at some of the emerging science of human evolution and how humans were able to track down animals that are much faster runners than us, simply because we developed a stamina for long-term pursuit and had the intelligence to be able to track different signs, so that, you know, on the African savannas where there were creatures much faster than us, creatures much stronger than us, but we were able to carve out a living because we could, over a period of days, track down the animals that we needed to kill to survive.
I guess one other area that occurs to me as we talk is in terms of the sort of fluid situation in which we find ourselves. One of the other things you alluded to, I think, is the declining power of nation states within the context of proliferating trade treaties, which actually supersede the constitutions of nation states in some cases, right? And I'm wondering if this is an instrument which gives citizens back some of that power.
Well, that's a great point that you raised, because I can give you an example from Costa Rica of where a previous Costa Rican government about 15 years ago issued some licenses to an American company called Harken Energy to drill for oil off the coast of Costa Rica. And that created a huge backlash amongst the Costa Rican people, who have a constitutional right to a healthy environment and also a deep-seated pride in the natural well-being of their country. And so during the next election in Costa Rica, that government was thrown out, a new government was brought in. The new government canceled those licenses that had been granted to Harken Energy. Harken Energy said, well, under international trade law, you owe us over $50 billion for the profits that we would have made if you hadn't canceled the contract. And Costa Rica simply said, we're not paying you a dime. And the government said that, the people were firmly behind their government in taking that stance. And Harken Energy to this day has never collected a dime from the government of Costa Rica. So I think that's a compelling illustration of the fact that countries, and you know, it's true, there's a lot of talk about the declining power of nation states within these global investment regimes, but the reality is that they still have the legal power to do, as sovereign states, to do what they want to do, as long as they're willing to stand up for themselves. And when a tiny country like Costa Rica stands up against a large oil company from the United States, I think that's a sign that there's a different way moving forward.
Yeah, this becomes very hot in the context of say, the Canada-China trade agreement, which is sort of poised over us. Mm-hmm. But presumably, if we had a constitutional right to a healthy environment, we would be able to stop some of that misbehavior, even assuming there is misbehavior, but I mean, yes, presumably it would give us a real instrument as Canadians to sort of say, no, you cannot do that to our country, you cannot do that to our environment. Right?
Yes, and in fact, one of the things we haven't talked about is that in many of these countries where the constitutional right to a healthy environment is recognized, those countries have determined that the current level of environmental laws and standards is a baseline which can never be reduced. So it means that countries can only strengthen environmental laws over time, which, if you look at the state of the world, makes complete sense. We have to have stronger laws, not weaker laws. And so a law like the one that was brought in Canada earlier this year, which rolled back key provisions of the Fisheries Act, which totally destroyed the Canadian Environmental Assessment Act, that law would have been found unconstitutional at the very beginning, and we wouldn't have had to have the wrenching national debate about how ill-founded it was.
And wouldn't necessarily have had to go to court, right?
No, in fact, it probably would have been reviewed by lawyers at the Department of Justice when it was initially drafted, and they would have told their government, told their elected superiors that this is unconstitutional, and governments generally don't bring forward unconstitutional laws.
I'm delighted by this conversation, in part because we don't tend to think, I think, ordinary Canadians who are not directly involved with the law, don't tend to think of the law as being having such creative potential, as being a creative instrument, as being a way of really having an impact on, we think of it as being much more reactive, I think.
Right.
And So this is very exciting to think that this perception, which is so widespread in the rest of the world, may give us some leverage.
Yeah, I think it's tremendously inspiring for Canadians to be able to look around the world at these tremendous stories that are coming out of Latin America, Scandinavia, even other places in Europe and Asia, and to look at those stories and go, well, why couldn't that happen here?
David Boyd, environmental lawyer, scholar, and teacher, a forceful advocate for the entrenchment of environmental rights in national legal systems. If you found this interview stimulating, you may want to look at our interviews with economic reformer David Korten and land reformer Alistair McIntosh. For the Green Interview, I'm Silver Donald Cameron. See you next time.